Hey y'all, it's Trish with Arch Legacy Firm, and I'm here for Whiskey and Wills. Thank y'all so much for joining us. Happy Wednesday. Cheers, everybody. So today I wanted to talk about wills. Wills are probably the most commonly known tool of estate planning. They're pretty much what everyone asks for or asks about when they contact me, or if I see any posts on Facebook or anything like that. Hey, I need to do a will, I need to update my will, I need to do a will and name guardians, things like that. I hear it all the time, I see it all the time. And that is because over time, traditionally, wills have been the most commonly used tool of estate planning. And wills are very, very important, and they are a part of every single estate plan I do. Every client that I have walks away with a will. So if it's a married couple, you actually have 2 wills, one for each. And then if it's a single, obviously you just have one. So what exactly does a will do? So a will is a legal directive that tells a probate judge what you want to happen with your estate. So it names an executor, it names your beneficiaries, how you want your estate divided, and who you would want as guardians for your minor children. And honestly, in my opinion, that last one is the most important thing that wills do, because the other stuff, it's better to have than to not have. But a lot of the times, people aren't really leaving their estate any differently than the law would leave it regardless. So for me, the most important part about wills are that they are a legal, formalized way to name guardians for your minor children. And y'all, if it's not notarized, if it's not signed, if it's not witnessed, even if you write something down, if you tell some of your friends that you want them to take your kids, if you have godparents or anything like that, that does not count as naming guardians, and a judge does not have to pay any attention to that. So unless you have a will or another executed formal legal document stating who you want to be the guardians of your children, the judge can decide whoever they want to decide. This could be family members, friends, parents, people that you wouldn't necessarily want to be the guardians of your children. So wills, for that reason and that reason alone, are extremely important estate planning tools. Now, wills are absolutely better than nothing in regards to naming executor, beneficiaries, how you want your estate divided. Absolutely. However, the big myth that I hear a lot is that wills can help avoid probate. Now, what is the probate process? The probate process is the court process that every family must go through after a loved one passes away, with very few exceptions. So the first exception is that if someone passes away with no assets, there is no probate. And by assets, I mean no house, no bank accounts, no life insurance, no anything, no cars, no nothing. The other way to avoid probate is if you are married and you jointly own everything with your spouse, including your house, with rights of survivorship. And that's very important, because if you own your house with your spouse as tenants in common, it doesn't count. So 50% of the house would actually still have to go through probate. So if you're married and you jointly own all your bank accounts, you've named your husband or wife as the beneficiary of any retirement and life insurance policies, then perhaps your family would avoid probate if you pass away. But other than that, outside of more advanced estate planning tools, wills do not avoid probate. Your family will not avoid probate if and when you pass away. So probate in Georgia, I'm located in Athens, Georgia, so this really applies to Georgia specifically, and every state's a little bit different. But in Georgia specifically, probate is going to take on average about 6 to 12 months pre-COVID. Now, post-COVID, we're kind of looking at more like a year plus right now, but it really does totally depend on where you live and where the probate takes place. So if it's in a smaller town, it may not take quite as long. If you're in Atlanta, good luck with that. So with probate, Basically, your family or the executor of your estate, so if you do have a will, you'll have named an executor. The executor will file probate with the court, and the executor's job is to gather all of your assets, to find them, gather them, appraise them, and do whatever is needed. And then once they have done that, the judge will allow creditors to come in, take what's owed to them. So mortgages, car payments, things like that. Then after the creditors have been paid, the judge will go ahead and give the go-ahead to tell the executor to distribute all of these assets to the beneficiaries according to your wishes. So it is a long process. It is a court process. It almost always includes probate attorneys, which cost a good amount of money. And while everything is tied up in probate court, it is tied up in probate court, meaning that your family will not have access to your bank accounts and to your money or to your house. They can't sell your house until the judge signs off on that. So it's really important to realize that probate is a pretty stressful, pretty expensive, and pretty long process. And if there is the likelihood that anybody is going to contest your will, this is the opportunity to do it because there's already an open court process going. So it is typically pretty easy to find attorneys to challenge a probate. Just ask my dad's step-siblings who challenged the probate for 4 years and dragged on probate for 4 years after my grandparents passed away. So y'all, probate can be really, really, really stressful. And it's super important to remember that a will does not avoid probate. A will is just a legal directive that tells the judge what you want to happen during probate to the best of his extent. Now, there are a few things that a will cannot do. Typically, wills don't have anything to do with incapacity. Wills don't avoid probate. And wills have very limited means of keeping an inheritance safe from kids after they turn 18 if you pass away while your kids are still minors. There are some testamentary trusts and things like that, mechanisms like that. But for the most part, if you have a will and your kids are minors and you pass away, then usually your kids will end up actually inheriting all of their assets when they turn 18. And until then, they can't inherit anything because minors cannot inherit. So even if you have the beneficiary designated accounts that typically stay out of probate, like retirement accounts and life insurance policies, if your kids are minors and you and your spouse both pass away, then all of these assets will also be put into probate process. So the only way to avoid the probate process, other than having no assets or owning everything jointly, is to have a living trust. And this is a slightly more advanced form of estate planning, but y'all, this should be the norm. This is my goal is to help the community call me and ask, hey, I need one of those living trusts instead of just a will. Because a living trust, in my opinion, is a better tool of estate planning because it's going to make it as easy as possible for your family on the back end by doing just a little bit more work on the front end. So that is a will in a nutshell. Again, wills don't have anything to do with incapacity. That's power of attorney, healthcare power of attorney, advanced healthcare directives, and they do not avoid probate at all. So cheers, everybody. Thanks for joining me. Please like this video if you found it informational. Please subscribe if you'd like to help me out. And I hope everybody has a wonderful week, and cheers.